I don't do appeals a lot, and this is different. Everybody's on notice today. This case is going to have, I'm going to give you a track to do everything. Everything's going to happen on time. Motions for extension will have to be really important. Like I've had to continue a trial because people died like the week before trial. Experts or lawyers got deathly ill with COVID. It's going to have to be that kind of thing. I'm not saying there's no extensions of time in this case, but you used all your extensions of time since September. Understood?
Yes, Your Honor.
And if anybody gets sick or has a family issue, 100% understand. And I think that's totally reasonable. But it's going to be those sort of things. Not I'm too busy or anything like that. So, all right. So let's talk about. I think the biggest structural thing is the motion to dismiss. I'm going to have Mr. Levin argue that the principal rules of law is appellant was supposed to file 4 separate appeals. I think he's right about that. But the case law says it's not jurisdictional. So it's not like Mr. Sheets is going to lose his 3, because I have jurisdiction. The question is whether they should be filed separately. So Mr. Levin, go ahead and argue the motion to dismiss, and then tell me what you're asking. You're asking me to dismiss the 3 and order the appellant to file 3 other appeals, which in my mind would be a nunc-pro-tunc back to the original 9-2-21.
No, Your Honor, and I'm familiar with the case law as it relates to late filing of a notice of appeal for something that was non-jurisdictional. I filed that motion to dismiss in an effort to bring attention to the court and to the appellant that procedurally they didn't follow the rules of procedure. There should have been 4 separate notices of appeal, 4 separate filing fees. I think what counsel was trying to do was to unilaterally consolidate these cases and take away the court's discretion in that matter. And so I filed the motion to dismiss to indicate primarily the fact that they made reference to 4 and only filed 3. And the appellant did respond with a motion to amend their original initial brief to include the 4th. So I'm fine with that, Your Honor.
All right. So, Ms. Levin, prepare an order that the motion to dismiss.
Your Honor, may I respond on that?
Well, I don't think you need to because you're going to win. I mean, it's up to you. I was going to leave them all in one case and have you just file an amended notice of appeal that lists out all 4 cases explicitly.
All right. If I'm going to win, I don't need to respond.
I remember the day in 1991, I was standing in court when a partner tapped me on the shoulder and told me that. So,
I learned that one a long time ago.
All right. So I printed everything out. All right. So, Mr. Levin, I think and if anybody disagrees with this, tell me, but I think the right thing to do is enter an order on appellee's motion to dismiss and appellant's motion to consolidate appeals. And they're both granted with leave to file an amended notice of appeal that is not pro-tunc back to September 2nd, 2021. Does that fit everybody's needs?
That does, but does that also include, there was one on the consolidated notice?
No, I'm not addressing Mr. I got to find I set his notice hearing aside. I'm not addressing Mr. Massey yet.
That wasn't what I was going to, and maybe you covered that and I just missed it in hearing what you said, but Mr. Sheets actually had 4 cases, underlying cases. They're essentially identical cases.
Yes. The motion to dismiss is granted. The motion to consolidate appeals across his 4, file a new amended notice of appeal to Mr. Sheets' 4 cases only.
Okay,
it'll be not pro-tunc back to September 2nd, so we don't have a jurisdictional issue.
That goes to all
make
4.
Sure your notice of appeal lists all 4.
Okay, all 4, and one of them was actually omitted from the original filing, so that.
Yeah, I remember it was in something, but it wasn't in the.
It was in the order.
Yeah. So
I understand your ruling, Your Honor. I just want to make sure Mr. Levin doesn't misconstrue it, and
right.
That's no punch at Mr. Levin. I just.
And Your Honor, that raises a point that I was going to bring up with respect to the consolidation, unless I misunderstood what your order was. We haven't talked about the motion for consolidation.
Yeah, we're not talking about Massey. This is just, I'm sorry, maybe it's appropriate just to talk about the motion to dismiss. I thought he had, I'm sorry, I totally misspoke and I tricked y'all. It's the motion to dismiss and the motion to amend notice of appeal. I apologize. So those Correct. Should be in the first order and say within 5 business. Let's see, today's the 3rd, right? So by the 9th, by March 9th, the plaintiff's going to file an amended notice of appeal listing all 4 of Mr. Sheets' cases, and it'll be not back to September 2nd, 2021. I'm probably using that Latin wrong, but that's the only one that comes to mind.
So are you asking for 4 separate notices, Your Honor?
I don't think that's necessary. I want one notice of appeal that expressly lists all 4. All right.
Yes, Your Honor. Thank you.
That solves both of those issues. It does not solve. All right. So then give me what do we have to do to get the transcript filed?
Well, I can file that, if I can file it online, I can file it immediately and provide Mr. Levin a copy.
All right.
I should be able to file it. If I can file it online, which I should be able to, I can go ahead and file it.
So, Mr. Levin, why don't you just do one order for this whole hearing? So you've got the first part. Next, court on case management orders that the transcript be filed and send it. I'm going to put this in the order. I have an email that I use for authority and proposed orders and stuff. So file it by March 9th as well. It will be electronic. And you can, I assume it's a PDF.
Yes, Your Honor.
Send it to G Gentile. So it's GGENTILE civil. There's no dashes or anything. It's just G Gentile civil. And then after that, all our emails are the same in the 20th Circuit. It's ca.cjis20.org. If it's in, you folks have no reason to know this. If it's something's filed in the court file, I can only read one page at a time. I have to click and it loads each page individually. If you send me a PDF, I can read it as fast as I can read it. So that's why I'm asking you to send the transcript, both file it in the court file for the record and send it to me so for my ease of review. All right.
We'll do, Your Honor.
And you got that, Mr. Levin? So get that petition or appellant's counsel will file and give me a copy of the transcript at that email by March 9th.
Got it.
All right. All right, so let's talk about, I'm going to give Mr. Levin the first crack at it because he filed the motion for compliance with Florida rules of appellate procedure. Mr. Levin, give me the, in chronological order, the dates that we need to deal with. And I'm going to I've already file the transcript. Is the next thing the initial brief?
Yes.
Okay.
And
then the next is the answer brief, right?
Correct.
And then after that, there's a reply.
Correct.
I did just enough appellate work, and I've been up at the 2nd District once as an associate judge to just be danger to you all.
I'm sorry, Judge.
Well, the 2nd District was fun, and I'm 2-0 at the Supreme Court, so that makes me feel better about the thousands of hours we spent doing those two things. So, although I'll tell you that there's a lost summer of briefing our first case at the Supreme Court where we read every case in the country on a point of insurance law. I mean, every case, and printed it out and put it in boxes and then created maps. So I may never recover from that. What other dates do we need to do? Initial brief, answer brief, reply brief, what else? From Mr. Levin's perspective, and then.
If either of the party requests oral argument, it would be the discretion of the court to grant that.
I'm granting oral argument, so to put it down for that.
Okay,
I was going to set oral argument. I just didn't say that yet.
All right. So the dates, Your Honor, I presume the dates for we need a date for filing of the initial brief.
And that is typically 70 days, I think, from the notice of appeal, and it can vary based on when the record was filed, right?
Yeah. So that 70 days is long past.
Under either math.
We're certainly amenable to a shorter date. In fact, we're ready to file it by March the 24th, if not sooner. We just needed to know whether it was going to be consolidated and how to deal with the record. That was a big point. How are we going to deal with it? So we can get this initial brief. And
okay. So I don't have a calendar in front of me.
March the 24th is the date I kind of pegged for the.
I just try and look at the weeks.
Yeah.
And then, Mr. Levin, how many days later would you propose to have your brief due?
Well, I was just going to check the rule and see what the rule says.
I think it says 20, but I mean, I'm not.
Would you allow me to put as the deadline whatever the rule says?
Well, I'm just going to order it now.
Okay.
The way we got here was, not having solid rules. So what I would do I'm going to make the initial brief due. It's actually a Thursday. It's March 31st. And then my proposal is, is to have the answer brief due. Is there any objection to April 29th?
Okay, I'm looking at the rule right now, Your Honor. I don't have the calendar right in front of me, but the answer brief would be due 30 days after service of the initial brief.
I was close. So let's do May 13th. By anybody's math, that's more than 30 days, right? You get all April and a couple weeks into May. How long for the reply brief? Just 10 minutes.
A response brief served 30 days after the answer brief.
All right, so here we go. 6/17, it's a Friday. All right, and then, so what about oral argument? How long after the reply brief?
Couple of weeks, Your Honor.
That would put us right around the 4th of July. How long do you think for oral argument?
How long would it take? Is it just going to be Zoom or in person?
Typically Zoom. We do everything but jury trials by Zoom.
I see. I don't, whatever they maybe 20 minutes for the appellant. Oral argument should be fair.
And understand, I will have read everything. I've read the whole record. I've read everything everybody filed before we start. So you won't have to spend any time getting me up to speed. I already was researching the different Supreme Court and Circuit Court of Appeals cases on these issues. So
very interesting case, but I'll be out of the country during the month of June. So I'm just kind of guarding that.
Yeah.
I should be here most of July and most of August, but.
Ooh. And I know I'm going to a family reunion sometime in late July, but I don't remember exactly when that is.
Your Honor, from the city's perspective, any day other than the first Wednesday, the third Wednesday, or the fourth Wednesday. Those would be city council meetings and stuff.
I heard you working. When you start talking like that, I went to school in Tallahassee, and some of my clerk jobs, we represented different folks that were representing government entities. And when you start talking like that, it rings an old bell for me. All right. What I'm going to do is I'm going to have Cheryl is on the call but can't speak to us. She can hear us but can't speak. I'm going to have her set oral argument for the first week of August. So what I want you to do is I want you to talk to one another. That's probably a trial week for me. And what I would propose to do is put it on August 1st because that's a hearing day. And let me see if I can communicate with Cheryl in the chat and see if, because I've got some long, 15, 20 day, 10, 15 day jury trials, make sure. Let's say Cheryl. Where is Cheryl? There she is.
There's a note at the bottom of the screen, Your Honor. Well, it disappeared, but.
Oh, all right. There we go. It's in the chat, so I don't have to answer that question. Either you folks want 11 or 1:30 on August 1st.
11 sounds good for the city.
August 1st. Either way looks good to me, whatever.
All right.
11's fine.
So, Mr. Levin, you're going to prepare in this order. It's I need you. I'm going to have Mr. Hendel do the notice of hearing for that day. So Mr. Hendel, do a notice of hearing for oral argument on August 1st at 11 a.m. by Zoom. Mr. Levin's going to have continue with his order. The initial brief is due on March 31st, the answer brief by May 13th, the reply brief by June 17th, and oral argument on August 1st at 11 a.m.
Got it.
All right. So we're moving. All right. That addresses appellee's motion to compel compliance with the Florida Rules of Appellate Procedure is granted, and then we've set those dates. All right. So let's talk about consolidating appeals with Mr. Massey. Are his dates the same? That's what I don't have loaded in.
Yes, his dates are identical. The hearings were on the same day.
Okay.
And I represented both of them on the underlying hearing.
Okay. So let's talk about the motion to consolidate appeals. Go ahead, Mr. Hendel. And this is consolidate means Mr. Sheets and Mr. Massey.
Right. So for all practical purposes, all the sheets are consolidated into one brief and one record. Is that correct, Your Honor?
Well, I don't know if the record was. No one's talked about did they occur, this case and then this case and then this case. I think the record needs to be separate. I don't mind you doing one brief, but it's got to be split up because each thing is a different moment in time that he's accused of violating a city ordinance, right? So we got to keep them separate. I don't mind if it's in one brief. I don't even mind if you need it, if you have an extension on the page limit to do that. Again, all Mr. Sheets.
Understand. Mr. Sheets, yes, one brief, and we can certainly separate the transcript into each individual hearing. That shouldn't be a problem. But as far as consolidating with Mr. Massey, these issues are essentially the same. The entire issue involves whether the F word, which was used in a sign, and I understand these signs were a little bit different, but the city's position is that the F word is totally out no matter how it's used in a sign. And so that's the essence of the appeal. All the legal argument will be essentially the same between Massey and Sheets, and between Sheets, of course, 4 cases. The legal argument's the same. There'll be slight nuances of facts, but distinction without any kind of legal difference or materiality that would impact or prejudice the appellee there. Appellees mentioned the possibility of prejudice by consolidating him, but there really couldn't be. If there was, any distinction, in fact, that's something that can certainly be pointed out in the briefing. But I think for the court's efficiency, for parties' efficiency, and putting this together, just simply consolidating these appeals would be the way to go.
Thank you, Mr. Levin. And by the way, just for our clerk, since we don't have a court reporter, it's the case that we're talking about consolidation now is the Sheets case 21-1015 and Richard Lee Massey versus City of Punta Gorda 21 CA 1014. I know Kim's sitting over here to my right, and we all know what we're talking about, but now she's got it. Mm-hmm. All right, Mr. Levin, go ahead about consolidating the 2 cases.
Yes, Your Honor. So I read with interest the case that was cited by Appellant's Counsel, the JMB versus State, 776 Southern 2nd 353, which talked about a consolidation of cases in appeals. And it identified different categories of situations for the purposes of consolidation. And what that case points out is that, for example, if the parties are identical, then you would treat the consolidation one way. If the parties are not identical, you would treat the consolidation differently. If the record is identical, then you can treat the consolidation a certain way. And if the record is not identical, you would treat it a separate fashion. So my concern is this. We've got, in the Sheets case, we've got 4 different records for each of the cases that were heard that day by the Code Enforcement Board, and a different record for Mr. Massey. So if the cases were consolidated for all purposes, theoretically, that would mean that there would be one record for applicable to the two appellants. And that's probably inappropriate. And without being able to know exactly what the appellant is going to be arguing in his brief, my concern is that one record serving all purposes, I don't think would work. And let me if take a step back and talk globally. I understand what the appellant's argument is, and what the purpose of the or function of the Rutherford Institute is, and they want to challenge whether or not our ordinance is an unconstitutional violation of free speech rights. And so I get that, and we can get to the heart of the case, which is a legal argument regarding the constitutionality of our ordinance on its face. In his motion for consolidation, he talks about that he wants to consolidate for all purposes. He talks about that their case is challenging the constitutionality facially and as applied with respect to the ordinance for each of the cases, and that the ordinance does not cover the conduct underlying the citations. And so, in the absence of what his various arguments are going to be, I think it may be inappropriate to consolidate the record for all the cases. But I would present this suggestion, hopefully, in the nature of judicial economy and in clarity of this action. I don't think that the facts are in dispute, and if the appellant is going to raise arguments about the facts in each case, there could be prejudice with respect to consolidating the record and consolidating all the appeals, because what might not have been a violation in one could be a violation in the other, and it would be difficult to take any of those cases up on appeal if they weren't unified. So my suggestion would be this: if the facts are not in dispute, if the appellant wants to consolidate the cases to be able to challenge the facial constitutionality of the ordinance, and if the appellants agree that they did violate the ordinance as written, but want to contest that the ordinance as written is unconstitutional, the city would agree to allow consolidation for the limited purpose of briefing that issue, which is actually discussed as the third option in the JMB case, where it says cases with independent records, which is what we have here, which have identical issues, may be consolidated only for briefing. And I think that would work well in this case, because quite frankly, the question before the court is the city's ordinance, as it relates to its definition of indecent speech, a violation of the First Amendment?
Any response?
Well, bear with me a little bit, please, Your Honor, because I am acting as participating attorney for another entity. And of course, I have my own vent and approach as well. There are two different constitutional elements. One is facial, and then as applied. The facts essentially, in a sense, the court could just look at the ordinance and hear the argument, the legal argument on the ordinance without facts, and perhaps arrive at a determination of facial unconstitutionality or unconstitutionality. However, in most cases, the facts are important to set a picture or the context of a case, or show the particular import that the case drives. And I think some of the facts here do make it very important that the facts be spelled out before the court. And, we actually tried to get a stipulation of facts with Mr. Levin. I guess it got a little too verbose for him, so he gave up on that. But I'm not faulting him for that. But there are certain material facts. Now that leaves the as applied argument.
You have convinced Mr. Pendle your motion to consolidate with Massey is denied. All right,
Okay,
let's stay on Mr. Sheets' case. So prepare an order that the motion to consolidate appeals between Sheets and Massey is denied.
Yes, Your Honor.
Yeah, we're not going to be able to. A lot of things we can fix with agreements that can't be fixed. All right, so let's move. I think we've addressed all the motions. Do you agree on Mr. Sheets' case?
I believe you have. I just want to make sure I understand the ruling on Sheets' case. I know about the notice of appeal, what we're going to do. As far as the record is concerned, the transcript, you want the transcript broken down into the 4 different hearings on that?
Absolutely.
Okay.
Yeah. I mean, I don't need to put any pressure on anybody, but this is the way I look at my job. I sometimes go back to Cheryl after hearing and say, I'm going to be the poster boy for X at the 2nd District. This case is important. It's just the right facts. It's in a gap in the law. The last time I said that was on a punitive damages issue, and I got reversed, and I was right. I was the poster boy for who under a certain theory of punitive damages, who has enough responsibility in a company to trigger that theory of liability. And I knew when I left the hearing, this case, we could all be, at the United States Supreme Court. I mean, I don't know if anybody has a better feel than I do than how likely that is, but I want to make it really clear in case anybody ever has to drill down. So that's why I'm not consolidating the 2 gentlemen, number 1. Number 2, that's why I need the transcript to be separated, because I don't want, I've met some of these lawyers that work for the 2nd District judge, and I don't want them having to sort through, make it, it's this case number and this transcript filed, or this, if it's let's say it's a 100-page document, pages 1 through 37 are that case. Make it has to be absolutely clear. I'm not saying it has to be multiple filings. I just don't know what that looks like. Is the transcript a transcript and exhibits from the hearing, photos or whatever? So, but make sure each case has a transcript and a record or an appendix that is just that case. Okay. For all four of Mr. Massey or Mr. Sheets' cases.
Appendix and a transcript broken down for Sheets, but 1 brief for Sheets. Is that correct?
That's correct. And also broken down by, like you say, you have facial and as applied, this case number, here's the factual. Just make sure that it's clearly split up. All right. Anything else on the Sheets case?
No, Your Honor, not from my perspective.
Mr. Levin?
Yes, so I want to make sure that I wrote down correctly what your order was. I understood that you were denying the motion to consolidate the Sheets cases with Massey.
Correct.
That's denied. Now, with respect, I don't know that we've heard any real discussion specifically with respect to consolidating the individual Sheets cases, and for which purpose. As I indicated, probably consistent with the JMB case, that where you've got Sheets, which is one party, but multiple cases, that the appropriate way to handle that and identical issues, that the records cases may be consolidated only for briefing, which apparently is distinguishable for consolidating for all purposes. So if you were going to consolidate the 4 cases relating to Sheets into one, our request would be that it be for the purposes of briefing, but there would still remain 4 separate records.
That's my intention.
Okay, well, that when you said that you were done with the Sheets case, I didn't write down anything as to what your order was with respect to Sheets, that case in particular.
Yeah, the 4 records, we'll have to have 4 different transcripts and records for each of his 4 cases, so that everybody from me on up, how far this case goes, will have no question about what the record is.
Okay. So essentially, Your Honor, you would be going with what the court said was the case. Those 4 cases would be consolidated only for briefing.
Well, an oral argument.
Yeah, I get that, and I understand. I just
Well,
wanted.
I don't know what I'm struggling with what that means, because then if there's a notice of appeal, there's only one Charlotte County Circuit case number and there will only be one order from me or judgment to take. It won't be a judgment; it'll be an order, an opinion to take appeal from. So there won't be 4 different Charlotte County cases. So I don't know I mean, I'm struggling.
Yeah, and Your Honor, I don't know that we got a whole lot of direction from the court when they were talking about that third option, but it appears to me that there is a distinction between consolidating for the purposes of the briefing versus consolidating for all purposes. And so to distinguish between what the court was saying, consolidating for all purposes, and what I think we recognize with respect to the ease of you hearing this case and the parties preparing the various briefs, that they be consolidated so that needs to be only one brief, but there are 4 separate records. And if you wanted to make some sort of factual issue regarding one of the 4 or one or more of the 4 cases, you can do that. And your decision ultimately would be based on whether or not you're going to overturn or uphold the code enforcement's order in each of those 4 cases. So I would prefer to just use the language of the court, so it's clear if there's any question regarding what was done here, is that it was being consolidated only for briefing, similar to what the court has suggested.
I don't know what that means. It's
I don't know
consolidated for briefing and oral argument. See, because I can totally see if the major, it doesn't sound like it in this case, which is why I'm not worried or leaning that way. If the real rub on these cases was the as applied argument, 20 minutes across 4 different cases might not be enough for oral argument because of that issue. If we're focusing on the facially invalid nature of it, you don't need, because up second you'd get 20 minutes or something. So you would have 80 minutes if you filed 4 different appeals. Here you're only going to have 20, and I don't hear anybody complaining about that, because the real focus is on the facial as opposed to as applied. That's what when I read those appellate cases like that, that's what I'm thinking. Are you going to, if they're all 4 separate cases, then you would set oral argument in all separate cases. You'd set them the same day probably, but you'd get 20 minutes to argue each one of them, right?
Yeah, and I
don't mind giving you, if y'all need more oral argument time, I don't mind that either. We'll
I'm agreeing with the court. I just can't waive as applied as I sit here.
Yeah. All right, so Mr. Levin, put in the order, they're consolidated for all purposes in this court, and the records will be separate. All 4 of Mr. Sheets' records and transcripts will be separate.
Will do.
That way, we'll keep heading down the road. All right, anything else on Sheets before we turn to Massey?
No, Your Honor.
Okay, so turning to Massey, 21 CA 1014. Is there any objection to handling it the same way we just handled Sheets? And what I would say is motion to consolidate appeals denied. He just has 1 ticket, right?
Yes,
right.
Your Honor.
So that would be denied. Appellant's motion for extension is granted, and appellee's motion to compel compliance is granted. And I say we use the same dates that we just used for Mr. Sheets. Any objection to that? And I would make the oral argument at 1:30, since I know I have 11 and 1:30. I don't want to try and shortchange and or have you work through lunch.
Are we going to have different times for different oral arguments on each case, or just one?
That's what I just said. As I said, I would do the oral argument. Remember, Cheryl said in the chat we could do Sheets at 11, but she also had 1:30 available that day. So I would say Massey at 1:30 for oral argument, and all the other briefing dates and the transcript the same.
That sounds good.
Would you, you indicated that you didn't want to have to interrupt for lunch. Would it make any sense, Your Honor, to have the Sheets case at 1:30, which is 4 cases, with the Massey case being just at 11?
I don't mind.
Well, most of the argument's going to come in on 1 case. I mean, it's it's the same ordinance. It's the same essentially set of facts. So, I don't know that really matters. Can you consolidate for the purpose of oral arguments and just set them together?
I don't want to do that. I want to keep them. I want to argue. Let's keep Sheets at 11. I understand what Mr. Levin is saying, and put Massey at 1:30. If we go all the way to 1:30 for some reason, we'll all eat at our desks while we're arguing. Okay.
No problem here.
All right. So Mr. Levin, if you would, in the Massey case, prepare an order that says appellant's motion to consolidate appeals is denied. Motion for extension is granted with all those same initial brief, March 31st, answer brief, May 13th, reply brief, June 17th. Oral argument in the Massey case will be August 1st at 1:30. Mr. Hendel's to do a notice of hearing by Zoom of oral argument. Appellee's motion to compel compliance with the appellate rules is granted.
Now, as far as my filing the transcript is concerned, based on this ruling, that transcript is going to have to be broken out into 5 different elements. I can go ahead and file the whole thing right away.
Well, wait. You're switching on me. Sheets, there should be 4 transcripts. I assume they were done sequentially. They weren't, were they argued all at once?
There was a break and a calling.
So file each transcript separately and say which underlying ordinance or case violation number it is. And then with respect to Massey, only file in Massey the Massey transcript for Mr. Massey's hearing and whatever,
I think the point is we're going to have to go back to court reporter and maybe retool this a little bit. So I said I could get it to you today.
What's the issue?
Well, they just gave us a transcript of all the hearing we designated all lumped together. So that's what I have now. So if
it's done in order, won't it be easy to just read it and go, okay, I don't know who went first, but Mr. Massey's here.
It would be easy to do that. It's right in order, and you can identify all the different cases, of course. So it really makes no practical difference.
Okay. So Mr. Levin, put in the order in the Massey case that the transcript will be filed with respect to only his case in 21 CA 1014 by the appellant by March 9th.
Got it.
All right. Anything else for Mr. Massey's case? Okay. All right, gentlemen, please comply with all the rules. Like I said, I am understanding of things that happen to us with our health and other things that we can't control, but otherwise I'm going to expect both the briefing schedule and the oral argument to go off without a hitch.
Absolutely, Your Honor. Thank you.
Thank you, Your Honor.
All right, Mr. Levin and Mr. Handel, thank you so much for your assistance today. Take care.
Thank you.
You too, Your Honor.
You as well.